Well, looks like that time where time is for a summary. So let's do a summary for video 10. Now, we've learned that prior to the Norman conquest of AD 1066, two parallel systems of rights to land were established, namely the king system and the tribal system. And either of these systems evolved through the conquest of the Celtics by the Romans, and next Germanic and Normandic tribes of Jutes, Anglo-Saxons, and Danes, whereby the individual was made subject to the laws of the king once he took of the king, or of the tribal system through a communal type evolution that fundamentally recognized the right of the elders to do what was best for the tribe. This is, bottom line, the basis of the social contract. These systems were a consequence of the era of agrarian settlements. Now, after AD 1066, the Normans began to establish a system of land laws that governed over defined sections of land called tenures. This era, still in effect today, historians coined as the feudal land tenure system. It was based on feuds or fees, whereas fee is a common vernacular used to describe a land or property interest today. Type of tenure interest depended upon a man's position or status. The word status was synonymous with the word estate, as described in cases in land or cases notes on land law by Boralaskin. The fees available at the time were of four sorts, namely military, socage, franquemont, and sergeantry or sergeantry, depending on what side of the ocean you speak. The service or fee was to provide night service under military tenure, agricultural services called socage tenure, salvation under franquemont, or under sergeantry tenure was to directly serve the king without having a lord in between, and essentially was an elite recognition. Sergeantry primarily consisted of the Anglo-Saxon elite who bent knee through force, whereas the military tenure consisted primarily of Normans. It is of note that the first three tenures also held possession, whereas the tenure of sergeantry, not always did that lord hold possession. Season is a very old word used in English law, which was to express possession of land or chattels. Over time, season became separated from possession to express a more technical meaning. It became customary, when referring to season, that it specifically referred to the one who held the freehold, whereas possession was a term used most commonly by the tenant who held a non-freehold interest. This also involved over time, as we will further understand as we go down in this video. If using today's property interest to provide a comparison of season possession, a landlord would be the one who holds season, the legal title, and the tenant would be the one who's held actual possession. As a result, we can express this relationship in this manner. If A, owning in fee simple, leases to B for years, B has possession and A has season. Sometimes A and B can both hold season, not of the same type though. In the case of B being granted by A an estate for life, B would have season of his life estate, as it is now a freehold interest, yet still holds feudal obligations to A, who also held season. Now, where we arrive at the terms of seized in service when considering A's interest, and seized in demesne or domain when we are referring to B's interest. Now, why is this important? Depending upon holding season or possession warranted the type of rights you could exercise in the case of being found deceased or ousted or some other tortious act against you and your estate. Certain rights also had time limits for the type of action available to them, and so it was imperative to understand the type of action you desired to pursue, one according to season or according to possession, whereby there are many instances, of course, when an individual held both, so he needed to ensure that he used the right type of action according to the order sought. Now, everyone else not of the status to hold these freehold estates, those not of the common law, held a non-freehold interest in land. These individuals were said to be seasoned dements or domain. Now here's the exception where we just learned that a life estate to be coined as seasoned domain, but you can see here that non-freehold estates were classified as being seized in domain. Now again, we are speaking about the evolution of how the system responded to tenants over time was gaining more and more rights. So of course, as those matters changed, and so did the terminology, the words that they were used or accustomed to be using started to change. And we can see this in everyday common English or any common language, whereby the dictionaries start to evolve based on how people are using certain terms. Now, returning to those holding non-freehold, seized in demesne or domain, they were those who held no direct right to bend the ear of the king, and so relied upon church and the manorial courts to serve their grievances while serving under these non-freehold tenures. These type of non-freehold tenures concerning a specific function were defined as villenage, which basically is a type of slavery, and later copyholds. Now, copyholds were made extinct by England in 1925 by means of the Law and Property Act. Copyhold, non-freehold tenures, received their name from the simple observation of the process of being entered into the manorial court roll. A copy of the parcel of land was recorded upon the manorial roll, making the one who accepted possession of this copyhold to be now do some specific bidding of their immediate lord. Now, if we look at all this entirely, once we, sort of simply reflect upon property interests of today, can we ignore the parallels that basically have eclipsed the mention of immediate lords in exchange for administrators called government, who then, through the vision of the right to tax a defined territory, are, for all intents and purpose, mimicking those memorial states of the past? A pyramidical structure is evident when we look at the entire system of land holding, with the king at the apex. Now we're looking at crown R at the apex, and tenant to no one. The tenures immediately traded thereunder, those that seized the individual in service, were freeholds of four sorts, and below them were a descending management structure that eventually arrived at the people who actually worked the land, whereby each layer consisted of a type of tenant right that answered to an immediate lord above them, all the way up to the king. Now I'm going to finish this video from reading from, once again, one of my favorite books, Cases and Notes on Land Law by Laskin, page 18, where he succinctly puts this all together in this paragraph. It reads, "It is to be noticed that neither quia emptoris nor the statute abolishing the court of wards and liveries purported to do away with the idea that land was held of someone, either the king or someone lower down in the order of holding. The recent important legislation in England, known as the Law Property Act, 1925, Imperial Act, Chapter 20, also leaves this idea untouched. As has already been pointed out, almost all feudal incidents that were the important elements in the relation of lord and tenant have, as such, disappeared, save in very exceptional cases. The only one that has any practical importance today is escheat. In this concept of holding land rather than owning it, the theory of the law of England is today what was 800 years ago, namely, that the owner, even when he has the largest possible rights in his land that the law recognizes, is not the owner of his land in the same sense that he is, for example, the owner of his watch. He holds his land in tenure under the sovereign." And with that, hit subscribe and like if you haven't done so, and I hope you enjoyed the video.